Okay, I guess we can start. It's a quarter past 1. So welcome everyone to our second session, the session on prudent corporate governance. I welcome all the speakers. I see they're present. We have had a little change within the first session. So the speaker that did not present her research during the first session will be moved to our session, to the second session in the end. So now we start proceeding with the conference program as planned. So we have ahead of us a very interesting session in which we will touch upon several of the topics that were already voiced during the keynote speeches and the first session. We will again talk about directors' duties, this time from a different perspective, one procedural perspective. We will talk about the material directors' duties as regards the vicinity of insolvency. And we will also talk about ESG reporting again and value chain due diligence. So lots of interesting topics ahead. As in the first session, the speakers will have 15 minutes each to present. I will be quite diligent as regards checking the time. So be prepared that I'll be interrupting you, unfortunately, if the presentations are too long. So without further ado, I would like to give the floor to my Polish colleague, Ariel Mucha, who is an assistant professor at the Institute of Law and Economics of the Pedagogical University of Krakow. Ariel is one of the few Polish company law scholars that has a stellar international publication record. This I wanted to underline here. I'm very happy to actually chair a session with two Polish scholars, which is quite rare. Ariel will today talk about a topic that when we look back at our first session and the keynote speech seems to be quite relevant, as we have come to the conclusion that directors' duties do vary a lot within the member states. And so we have also seen the heated debate around the corporate sustainability due diligence directive and the Commission's proposal to harmonize the director's duties to some extent. So Ariel's topic on the law applicable to director's duties seems very on time. So go ahead, I mute myself.
Okay. Good afternoon, everybody, and thank you, Anne, for this introduction. And I also would like to thank organizer for inviting me and having me today online in this fascinating panel on the prudent corporate governance. It's my first time presentation during this great conference. So let me turn to my presentation. I hope everybody sees, everybody hears me. There was a little snowstorm around, but I hope my internet connection would be as good as it was at the morning. So yeah, I hope it's working. Yeah, it's working. So let me turn to my presentation, which will concentrate around the issue of the law applicable to the duty and liability of corporate directors in Europe. And because of time limits, I will speak only about company law or tort law qualification in terms of private international law. So in other words, the question I would like to answer is how we should characterize action undertaken by directors, either as governed by Lex Societatis or Lex Delicti. And the presentation will be based on the latest development in this area, in particular, one of the latest Court of Justice decision from 10th March 2022, BMA AG case. I will first present some backgrounds remark, then present the most important thesis coming from this decision, and then offer my thoughts about it. And final part concerned conclusion, some of them beyond this decision. So starting with some general background thoughts consideration. So even though the company law in Europe have been gradually harmonized, no general framework for directors' liability was introduced so far in Europe. So we have no general standards of liability, and each member state are free to regulate this issue. As a result, there is a need to regulate potential conflict of law with international private law rules that would indicate which law applies to directors' duties and liabilities. And starting from 1999, a series of Court of Justice decision began to carve application of so-called real seat doctrine in line with the liberal interpretation of EU treaties, in particular Article 49 in conjunction with 54, so the provision that embraced the idea of the freedom of establishment. And in result, most member states currently follows so-called incorporation theory and acknowledge that the company is governed by the law of the state in which the company was established in the first place. But the law applicable to the company in general is the very first question we need to ask. The second issue, equally important, is what is the content of the Lex Societatis and what is the relation of it to other fields of law, like the tort law, insolvency law, securities law, and so on. So this is justified since various legal obligations, as this was already discussed, define the director's duties, and each of them might be subject to different international private law characterization. So far in Europe, we have no legislative instrument harmonizing the law applicable to companies, even if some informal proposal was presented already, they were not offering significant guideline as to how resolve the problem of characterization between different fields of law, including company law. So the only legal act we can based on now in case of conflicts between corporate and tort law is Rome II regulation on the law applicable to non-contractual obligation. And here in Article 1, Section 2, point D, we can find an exclusion from the application of this regulation, which concerns matters related to company law, like creation of a company, so incorporation of it, legal capacity of a company, internal organization, or winding up of companies. And what is important for now, it also includes the personal liability of directors and shareholders for the obligation of the company. And as a result, the personal liability of directors and shareholders for the obligation of the company falls under Article 1, Section 2, point D, and as such is not governed by the Rome II regulation. Ergo, it is likely to be governed by the Lex Societatis. And this conclusion could end my presentation, actually, because the question posed by the very beginning of my presentation was about the law applicable to such situation. But it's not the end because there, apart from legislative text, there is also an interpretation of the Court of Justice. And the most important case for our issue today is the latest decision in the case ZK versus BMA AG, a case which is based on rather simple sets of facts. Just in short, the liquidator in the bankruptcy of a Dutch company brought an action for damages against the German grandparent company BMA AG. The basis for the claim was a breach of a duty of care to the creditors of a Dutch insolvent company. And this breach was allegedly conducted by the grandparent company. And one of the few problems addressed in this decision by the court and the Advocate General was, does the exclusion, as I already mentioned a few times, from Article 1, Section 2.d to apply to such a claim? And okay, it's working. So let's see how the issue was addressed. First, the Advocate General opinion. And she started with some general remarks like the concept of company law should be interpreted autonomously. But then Advocate General stated that what must be done in such a situation is we must make a distinction between internal affairs, relation or life of the company, which is subject to exclusion, and on the other side, the external relation covered by the Rome II regulation. And when it comes to internal affairs, they concern matters like incorporation, legal capacity, internal structure, and dissolution of the company. But there is also a gray area. And here we may find personal liability of directors for the obligation of the company in the opinion of Advocate General. And in her opinion, it is not, those elements are not purely internal from a company perspective, since it is not always clear from what reasons directors are labeled for. And she next explains if a provision on non-contractual liability is so rooted in a consideration specific to the company law context that is irrelevant outside it, then this takes precedence for classification purposes. And to be more precise, Advocate General says that for deciding if a non-contractual obligation is or is not covered by Article 1, Section 2.d of the Rome II regulation, we must analyze the purpose, the goal of the regulation, and if the liability to shareholders and directors is rooted in the company law purpose, then the exclusion from the Rome II regulation is activated. But if liability arises from the general breach of obligation of principle nemine ledere or from another specific title, then Rome II might not, then Rome II might be applied. So if there is a breach in nemine ledere principle, then we apply Rome II and all rules that are coming from the regulation. And following, when it comes to the court final decision, the court followed most of the arguments presented by the Advocate General. The court drew the line between corporate law and outer world by reference to the structural aspects of company, and doing little to explain this term, the court stated that the personal liability of directors and shareholders for the obligation of the company is not an element falling within this definition. So as a result, in order to distinguish the company law from others body of law, one must look at the source of non-contractual obligation, which is either specific to company law or it has this extraneous purpose out from the outer world of the company law. And in this context, the court states that what is important is a question: to whom does a director bear a duty of care? If this duty comes from the general duty of care, erga omnes, it determines the application of the Rome II regulation. And actually, this brings the court to the end of the reasoning, since it is up to the national court to decide what character has the duty prescribed in the member state law. So now I will share with you my thoughts and impression about this decision. And there are just, I would say, main points of critique I can express in short time. So first of all, in my opinion, there is no added value after this judgment, after BMA AG case, even though the ruling underlines the internal and external aspects of a company. The court made little to provide any explanation what constitutes those fields, spheres. It is, I would say, it is only a paraphrase of the obvious fact that in formal sense, in legal sense, we distinguish these two areas of law. And the poetic, somehow, language suggesting that the company is a kind of a box with internal and external borders, it's not conclusive. In real life, in my opinion, it is much more complex institution which operates under the law, which at times mixes different aspects of internal organization. We called it most oftenly corporate governance, with some external protection instruments of different stakeholders. Secondly, provided test is, in my opinion, I think it's only a smell test based on the idea of the clash of legislative purpose method. So the key is here to determine the purpose. But what is the purpose of company law or tort law? The court did not give any clue to this regard. And obviously we can find and draw some goals in both fields of law, but those purposes may differ among member states, and it may create some significant additional uncertainty. And for these reasons, in my opinion, we have received an idea what to do, but without instruments to apply it in practice. In other words, in most cases, it is unfeasible to conduct this test proposed by the court in an efficient way. Third point, the criterion proposed is, I think, is prone to abuses from the member states. So it is enough for member states institution to invent and recognize that directors have special obligation to third parties. And by doing so, this gives grants for holding them accountable under the Lex Loci Damni law. So probably this member state standard. I'm finishing. And another issue, what are the limits for member states when they create directors' obligation against third parties? Do we apply in such situation Gebhardt test, for example, so the proportionality test? We don't know, because the court did not address this issue at all. And last thing, maybe the strategic ambiguity represented by the judgment serves some greater good. And I would like pose some examples. So let's consider following really fast some situation. We got a Swedish company producing furniture. And through the chain of suppliers and middlemen, the company is contractor with a Belarusian factory providing elements to these furnitures. And in the factory, we got political prisoners who are forced to work without any remuneration or basic humanitarian condition. If we assume that directors of this Swedish company have a general duty of care to those employees, we need to find a law applicable. And after BMA case, this law probably would be determined by Article 4, Rome 2, so the Lex Loci Damni, the place where the damage occurred, and in this case, it would be Belarusian law. And I have no idea what is the law in Belarus, but we can safely assume that the standard of protection in such a case is lower than this in Sweden. So by applying the approach, or one of the interpretation of the approach of the court in BMA AG case, what we achieve here is no real protection for workers. And concluding in very short way, as we have seen, current system does not work as it is not able to resolve real life issue. We are now left without regulatory stability and no effective protection of vulnerable constituencies at the same time. So I think there is a need in Europe for a legislative reform, but first we must decide what we really want: more stability and certainty for business, or more flexibility for courts to be able to protect individual and achieve some other sustainability aims. On this, much depends what kind of measure we should apply into legislative instrument. Thank you very much. Thank you for your attention. I let Anne the floor.
Thank you very much, Ariel, for your very interesting presentation, and also the last example, which clearly showed to all of us and exemplified like the problems that arise from the judgment you discussed. So lots of open questions here. The next presenters will be Dusan Jovanovic and Nikola Jovanovic, both from the University of Maribor. And they will present us their research regarding ESG reporting and further explore the topic that has already been lightly touched upon in the first session. The floor is yours.
Thank you very much. So there is really a coincidence that me and my co-author have the same surname. We are not related, but we are actually find it as a topics. So I would like to tell the thank you organizing committee and organizers to accept our article and a possibility to presentation. And because I have a young strength next to me, he will share the floor and presentation of our work to everyone. Thank you.
First of all, as everyone hear me, so if you can, one second, we need to turn off the sound on another computer. Sorry, 1 second. Yes. Do you hear me now?
Yes, now it's fine. Thank you.
Okay, I'm sorry for that technical complications. So, first of all, hello everyone. I'm Nikola Jovanovic, LLM student at University of Maribor, Faculty of Law. And today I will introduce our topic, maybe in some wider and more abstract way, but some that already is mentioned in the earlier presentations, but as I said, in maybe one more abstract way. So our title is Corporate Governance Challenges at the ESG Reporting. First of all, 1 second, there is some complication. It's okay. So I will first introduce our key topics. preserving and protecting of environment as one of the biggest challenges that modern generations have. So in that that sentence that is from the European Green Deal, I just want to emphasize that the preserving of environment is our goal, the goal of our generations, and we have to find a suitable solution for that. So we cannot wait anymore, as it mentioned earlier. That is a key problem of our society in this moment. After that, in my next slide, I will introduce green transition to the more sustainable economy as a changing of paradigms. So in that part, I will try to explain how a green transition as a process need some kind of rethinking or re-questioning our key paradigms of our way how we're doing business and how we live at general. Next slide will talk about how non-financial reporting and the green transition are connected with the institutes of ESG reporting, and because of that, that thesis that non-financial reporting is an implementation tool of green transition in the corporate law. In that manner, I want to emphasize that. After that, I will talk about our main part of our presentation is challenges and liabilities of companies and their bodies in relation to ESG reporting. In that kind that through our research, we want to emphasize what are the main challenges that we have to solve before we start solving another problems and another challenges that are consequentially linked to the first main challenge that is also mentioned earlier, but I want to emphasize once again on the more abstract way. And at the end, I will try to emphasize some positive practices related to corporate implementation of green transition in another states such as India, Switzerland, and USA, some specific new disclosure amendments of the SIC. So first of all, green transition is a changing of paradigms. At the beginning, I want to, as some kind of introduction, say something about Earth Overshoot Day. As many of you, I think know, there is one organization, Earth Overshoot Day, that counts when the date when we as a society consume all resources that our planet Earth can regenerate in that year. This year is the 29th of July 2022, and it's constantly shortening. If we see in the last 50 years, constantly that day is coming earlier and earlier. That means that we live more and more unsustainable, and so that I want to emphasize as an introduction to my next topics. So what we think when we say green transition as a changing of paradigms. So green transition as a process needs a change of our, or at least rethinking of our key concept of our economy today. So transition to the circular economy from the linear concepts. As we know, linear concepts mean that we produce, consume, and then abandon as a waste without reusing, without recycling, and that we have to change to the more circular economies. Another concept that we have to rethink is I wrote there abandoning, but not necessarily abandoning. Also, at least rethink is the concept of infinite growth. Is it infinite growth only goal that our economies have, that companies have? Is it their main goal? Do we have some more specific goals? Do some more specific stakeholders that we have to include? That is all open question and challenges that we have to find a suitable solution and answer. Next, ESG reporting as an implementation tool of green transition. So, as many of you mentioned earlier, what is non-financial ESG reporting? I will just say that I wrote that in one definition from our article, but you already know that, so I will not use time for that. After that, we have EU legislation. I just wrote to some kind of path through the first of all to the agendas, to the books, the green book, white book on sustainability, and then taxonomy, and then a non-financial reporting directive, and then we had right now the corporation sustainability reporting directive that constantly widening scope. So in that part, EU shows that want to widen the scope of companies that have to report specifically to that supply chain that we mentioned also earlier. And I put it down the future/present of corporate sustainability due diligence directive, also as a part of the new EU legislation about the corporation sustainability. Next, so this is our main topic and main challenges that we want to emphasize here. So we mentioned to the conference earlier, more time we mentioned that debate between stakeholder and shareholder capitalism, and that I think that is the biggest challenge, to find the suitable solution without going in that trap, because we think that biggest challenge is correlation of the lucrative purpose of companies versus sustainable development. Because of why? Because what will happen when the lucrative purpose of companies, for example, in Slovenia, we have in our Corporations Act, Article 3, that strictly define corporations as a profitable legal entities. I said that not strictly definite, but that is a main purpose of companies. And what will happen when we will have the purpose of company as a profitable versus and find on the another side or opposite side to the sustainable development? How will management solve that problem, or how will states solve that problem through the legislation, to the proper legislation, and find suitable solutions? When we find solution for that part, so when we find solution between lucrative purpose of companies, or if you want it, shareholder capitalism versus stakeholder capitalism and sustainable development, we will find the answer on all another, if I can say, legal questions, such as regulating and making accountable the governing bodies for non-implementation or lack of commitment to the green transition. Because when we find the solution in the theory, in the values, that we all can agree about, then we find a suitable legislation for that part. So they are interconnected, and we, to our research, wanted to emphasize that those challenges and topics that we need to resolve before we find some legislation solutions, because now there is a more gray area that management have, because don't have every time the suitable solution, and they will always go to the shareholder and to the race to the bottom, as the colleagues mentioned earlier. In the end, I want to stress or emphasize some specific positive practices that are related to implementation of green transition. For example, India, they did amendment to the Corporations Act to 2021, when they specifically did a strictly reach that companies have to reach the goals that companies have to reach, and they have to form special funds and create special policies, corporation and for corporation sustainability reporting, and they're also liable for non-implementation those specific policies. After that, I want to mention the Switzerland amendment, the criminal law about the toxic minerals or chain of supply, those Switzerland companies that import the specific minerals from specific countries that maybe have a risk of the child labor, and the management and the governing body of that company, if it's find that they are using that, they're importing that kind of minerals from that countries, they can be also criminally liable. At the end, I want to emphasize the new climate-related disclosure requirements from SEC. So the Securities Exchange Commission did the amendments in that part of the company law, and they want to more and more ESG reporting in from the companies. At the end, I want to mention also that they're linking the management salaries and compensation with reaching of ESG goals. That is also good practice. We also find some kind of solutions, or not find, but mention some solutions maybe in our article that is part of this conference also, to the legislation of state, to the tax, to that part, and not only to the ESG reporting. So thank you all for your attention. That's all from my side. I think that I'm in time. So professor is also here. We had 2 computers, and that is a complication. I'm sorry once again for that. So that is all from our side.
Thank you very much for these interesting thoughts, and also for respecting the time limit, as we have a session with more speakers than initially planned. That's also quite important. We are continuing with, again, a presentation that will be presented, yes, I assume by two presenters. We have Tina Jakupak and Zerika Breges, who both share some important experiences in the judiciary. So we're curious about that, and they will discuss the issue of disqualified directors. The floor is yours. Welcome.
Thank you, Ms. Weber. Thank you all. Thank you to organizers to having us here, third time in a row. So thank you very much. Due to unstable connection, I will turn off the camera because I don't have any other solution. I asked the administrator what to do, so I will share a presentation, but with camera turned off. So sorry about this inconvenience. Just to share the presentation. I hope that you all see it clearly.
Yes.
Thank you very much. Thank you. So the topic of our presentation today, and the topic of our manuscript, is about the digitalization directive, and about part of this digitalization directive about disqualified directors. So you probably all, sorry, I have some issues, sorry. Let me stop the sharing.
No.
Yes.
Just click on your presentation. You have to initialize your slideshow because you don't have controls. You have controls now.
Thank you very much. Thank you. Thank you. So you probably all heard about this directive on digital tools and processes in company law from 2019, and about the goal of this directive, that all member states are required to, until August 2023, to lay down a set of rules defining what kind of persons are not legally allowed to be directors of companies. So we build our paper and this presentation around the long-standing critics on the EU company law regime and the transposition rules of. So in the paper and on today's presentation, we will give you state of play about this digitalization directive in Croatia. One of the positive aspects of the digitalization directive is that it requires member states to clearly state the reasons for which persons are not allowed to be company directors, and that the list of these disqualified directors must be maintained. So actually, company directors risk to lose their rights of setting up or representing a company if they fail to meet their legal responsibilities. So the disqualification aim should be effective not just on the national level, but throughout the European Union. What does this digitalization directive says about disqualified directors? Well, it says that member states shall ensure that they have rules on disqualification of directors. That's the first thing. And the member states may require that persons applying to become directors declare whether they have been disqualified. Also, member states may refuse the appointment of a person as a director of a company where that person is currently disqualified. Also, furthermore, member states need to be able to communicate information about the disqualification of directors in one member state to other member states in due time. So basically, these are what the digitalization directive says about disqualified directors. What about Croatia? State of play of transposition of this digitalization directive in Croatia is it's like that. So we changed in Croatia, actually amended Companies Act in March 2022. And the Croatian Assembly called Sabor voted to amend Companies Act. That law, Companies Act amended, entered into force on 1st June 2022. Provisions on disqualified directors have to wait for a rule book by Minister of Justice and Administration for register on disqualified directors. So the minister should and will adopt the rule book on disqualified directors by July next year. But due to directive, the minister responsible for the judicial affairs should organize these records by August 2023. But due to some other issues in Croatia, it's probable that this rule book will see the light at the beginning of this year, actually in January 2023. Simultaneously with amendments of Companies Act, Court Register Act also was amended on the same day, because these two acts are cause and effect principles mutually connected, and they have same goals and the same purpose, mainly due to this implementation of the digitalization directive. So it is established that the text of the final proposal of both acts contain statements on the compliance with the acquis of European Union. So under Companies Act, Croatian Companies Act, any natural person who is fully capable of doing business can be a member of the board. The articles of association of every company may specify the conditions for appointment of board members, but according to Companies Act, the board member cannot be a person who has been punished for the criminal offense of abuse of trust in business operations, fraud in business operation, causing bankruptcy, favoring creditors, or violating the obligation to keep trade and business books from the Criminal Code of the Republic of Croatia for a period of 5 years from the date of finality of the judgment by which he or she was convicted, with the fact that at the time spent serving a sentence is not counted. Or the person who has been punished for a criminal offense of another state, which by its essential feature corresponds to the criminal offenses before mentioned in Article 1. So also a board member cannot be a person against whom a security measure has been imposed, prohibiting the performance of an occupation that is fully or partially covered by the subject of company business for the duration of the ban, and the one who is prohibited in another country from performing professions that are fully or partially covered by the company's business for a duration of that ban. So minister responsible for judicial affairs will organize and keep the records. So Minister of Justice will keep the records of persons who cannot be members of administrations, according to this before mentioned, and the minister responsible for judicial affairs shall prescribe the content, manner of conducting, and conditions of use of the evidence by the rule book, which will so hopefully see the light in January of 2023. So Croatia in the future will keep but a non-public record of disqualified directors. So it will define criteria for disqualification. We will keep a list of current and former disqualified persons and give non-public access to this list. So what does it mean non-public? Well, right to see that list and the record will have only the judges who are dealing with these cases. So that's why the record will be non-public. So only the judges in court register will be able to see that record. So I mentioned before that Croatia changed not just Companies Act, that we at the same time changed the Court Register Act. And so we extended the provision on disqualified directors to other persons when we as judges examine the application for the registration or change of a member of the board. So a member of the board, executive director, member of a supervisory board, member of the board of directors, procurator, and a liquidator of a company. The court or the judges in the court register will check whether that person is registered in the register of persons who cannot be members of the board, which is maintained by the, as I said before, minister responsible for judicial affairs. In a case of doubt, the court register can check through the registry linking system whether that person is in another member state is prohibited from performing a profession that is fully or partially covered by company business. So we have, you are probably familiar with BRIS, Business Register Interconnection System. We will be able to check this through this BRIS register to check foreign directors, foreign member of the board, executive directors, etc. So the aim is that a company cannot knowingly permit an eligible or disqualified person to serve as a director. A search on the disqualified director register, as well as criminal and reference checks, must be a part of the nomination process before an individual is appointed on the board. But if that person comes in front of the court register judge will deny the enter to the court register. So that's the key benefit. Absolutely, we have to bear in mind that we should the digitalization directive should be applied in compliance with EU data protection law, and given that let me say some practical problems that we as judges do see in this way, that given that the company foundation has to be completed within 5 working days, it will be very difficult for Croatian court register to reach out to other member states, public authorities, in order to conduct a check of the applicant's qualification to set up a company. So you see the problem here. All participants in this conference from Croatia who are dealing with court register, I think they know what I'm pointing to. So 5 days will it be enough? We will see. So Croatia is waiting for the disqualified directors register. it should include all the details of directors disqualified, so name, address, date of birth, nationality, OIB, and other data that are necessary. What I would like to say for the end of our presentation about another piece of news in Croatian company law. So we have adopted the Moneywell report, and the government of the Republic of Croatia adopted the conclusion on the acceptance of the action plan for strengthening the effectiveness of the Croatian system of preventing money laundering and terrorist financing, which contains measures and activities whose goal is to further strengthen the Croatian system of preventing money laundering and terrorist financing. So, due to that, by the end of the year, this year, the Companies Act will be amended by this action plan, and due to Moneywell report, I don't know exactly how will it look, this new rule in Companies Act, but I suppose that we will interfere in Companies Act in the way that is shown on the slide. So probably we will do it to that. So at the end, I will just express my opinion and opinion of my colleague Judge Bregas. We are judges. So as a judges at the Croatian court register, we deal with lots of cases. You probably know, because there are 150,000 companies in Croatia, which 65% of them are entered in the in Zagreb Croatian court register. So every day we deal with lots of cases, and from the perspective of a commercial court registered judge, all of these before mentioned seems well thought out, but it remains to be seen how the law will apply to existing technology and allow judges to view the registers of disqualified directors when making decision. It is likely that the adoption of the rule book alone will not be enough, but greater cooperation will be required from the state bodies within Croatia and subsequently from member states. So this is what we just want to say at this conference. We have a paper manuscript that is much broader than this, but we want to make public to the Croatian participants especially, but also to foreign participants, that technology is, let's say, main problem here in court register. So thank you very much for your attention. So hope to see you soon. Thank you.
Hey, thank you very much for these interesting insights into the Croatian system. And I think we will get, as I see several questions in the chat, we will discuss later in the session that we have reserved for questions. Now I have the pleasure of introducing another Polish colleague. Marcin Mazgaj is also an assistant professor at the Institute of Law and Economics of the Pedagogical University of Krakow, and has similarly an impressive international publication record. I'm very happy to host you in this panel, and Marcin will address a very interesting topic that has actually been mainly discussed, I would say, in the criminal law scholarship and has not been voiced so clearly in the company law scholarship. So I'm very eager to hear about identity theft in the company law context. The floor is yours.
Thank you very much, Anne-Marie. Just to make sure as regards the technical issues, am I visible and audible?
Yes, you're audible and you're visible.
Okay, thank you very much. Thank you, first of all, to Professor Horak, Professor Szafranko, and Professor Polianiec, and the other organizers for making it possible for me to present my paper during this conference. It's my honor and my pleasure to take part for the second time in a row in the company law conference organized by University of Zagreb, and I'm always impressed by the perfect organization of the event. Ladies and gentlemen, we are meeting during the Football World Cup. As far as I know, so far Croatia and Poland belong to a very narrow circle of teams that so far have not lost a goal in the first match. The problem is that both Croatia and Poland also belong to a very narrow circle of teams that so far have not scored a goal in the first match, but we'll fix that in the next round. My reference to football at the very beginning is not a coincidence. There is a link between football and the topic of my presentation, as I would like to start my presentation with a real story of a real Polish company, a story that was heavily covered some time ago in detail by the Polish media. The story is, the link consists in the fact that the owner of that Polish company was a Polish businessman of Turkish origin, Mr. Sabri Bekdas. Some time ago, he was the owner of Pogoń Szczecin, which is currently one of the best Polish football clubs. But the story I want to tell is related not to that football club, but to another company of Mr. Bekdas. That another company is named Reformer Development. What's so special about that company? Well, a few years ago, their office got a call from their bank with an invitation to visit the bank in order to update the documents due to the change in the management board of the company. At first, the employees of the company ignored it, as they were sure that no changes in the management board of the company took place. But the next day, the bank called the office again and renewed its request, as well as mentioned that the new management board is revealed in the official commercial register. So the team of Reformer Development checked the register, and they saw something like this. The court entered a person named Kenneth Marcus Leung as a new president of the management board of the company. The problem was that nobody in Reformer Development had ever heard of Kenneth Marcus Leung. No shareholder has ever heard of him. No board member has ever heard of him. What turned out later was that somebody drawn up minutes of the shareholders meeting of Reformer Development, where a resolution on appointment of Mr. Leung was included, and later that somebody forged the signatures of the shareholders on those minutes. The court did not verify the authenticity of the signatures and simply entered Mr. Leung to the registry, and well, he was visible in the registry as the president of the management board for about 2 months. In the meantime, somebody tried to take out a few bank loans on behalf of the company, and they tried to use the real estate of the company as a collateral. So the question is, how could we prevent corporate identity theft? How could we prevent such situations happening? Well, there are some examples from some Western European legal orders. For example, in Denmark since I think 2020, there is a requirement of confirmation of appointment by the appointed person via personal official digital mailbox that every resident of Denmark has. In case of non-residents of Denmark, a copy of passport is required. In Poland, the legislator has recently introduced some new ex-post measure aimed rather not at preventing identity theft, but rather at quick response. The official newsletter issued registry courts. Well, everybody order the registry court to automatically inform her or him on entering that person into the register, or as well as on any changes related to the selected companies. But the real question, as regards the case I just described, as regards the reformer development case, is actually who would be liable towards the creditors for the obligations assumed by the fake director, by the person entered into the register but not being the real director. This is due to the fact that generally the person wrongfully entered into the commercial register does not become a member of the management board, but may assume obligations on behalf of the company anyway, as the third parties acting in good faith rely on the public commercial register. In Poland, we have a very specific rule introduced in Article 299 of the Polish Code of Commercial Companies. You can see the content of it now. Generally speaking, the members of the management board are liable for the debts of the limited liability company. But the real problem is that this provision refers only to the de jure directors, not to the shadow directors, not to the de facto directors. Yeah? So the question is whether such third parties who entered into contracts with a company represented by a shadow director, by a fake director, could hold that fake director liable for the company's obligations assumed by him on behalf of the company. Well, and the major problem we have in Poland is that we have no rules related to liability of shadow directors, which is not that common in Europe, but there are certain legal orders where the legal situation, the legal standing of shadow directors is expressly regulated. One example is the law of England, where the shadow director is defined, and the shadow directors may be held liable in case of companies' insolvency. Also, in France, there are certain rules related to de facto management of companies. So, well, the question is whether actually the issue of shadow directors is a practical problem or just a theoretical one? Because of course the case I just described is a very specific one, but well, on the other hand, for sure it is clearly visible that there are many cases where one person is a board member in, for example, 50 or more companies. I would, however, argue that it does not necessarily constitute an actual problem. For example, if these companies do not conduct actual business activity, the scope of necessary actions of the boards is limited. Nevertheless, on the other hand, it is clear that at least in some of these cases, the companies are active and the shadow director is somebody else than the formal one. And of course, here is some room for the legislative intervention. But when we, however, think of what sort of legislative action it should be, another problem arises. Because we could use two sorts of measures, the ex ante measures or ex post measures. Ex ante, so the ones preventing the abuse of the director's identity. And here I let myself list a few examples of such measures that were discussed in the literature so far. In certain Western European legal orders, in particular in Denmark, there was a discussion whether the law should introduce a maximum number of positions held by a specific natural person. On the other hand, in the United Kingdom, there was also a discussion related to banning a possibility of providing a general power of attorney to any person on behalf of a company, because the general power of attorney might be the mechanism used by the shadow directors. On the other hand, in Sweden, for more than 20 years, there exists a general regulation requiring the directors of the company to actually perform management of the companies. As regards the ex post measures, there's generally speaking one simple solution, so the liability of the shadow director, the de facto directors. And if we consider the possible measures, the possible solutions, we can easily see that all the ex ante measures have some drawbacks. Most of them are quite arbitrary or extremely difficult to implement. Firstly, if we would introduce a maximum number of positions held by a selected natural person, that number will always be arbitrary. If we set the norm at the level of the threshold, at the level of, let's say, 40 or 50 companies, it does not solve the problem, because sometimes the significant problem will arise even in case of a person being a shadow director in just one company. The solution discussed in the United Kingdom some time ago, so the ban on general power of attorney, is also ineffective, as the clue of the problem is not necessarily the formal influence and the formal mechanism, but rather the informal influence of shadow directors. So banning general powers of attorney would definitely not be the solution. As regards the legal duty to actually perform the management by the director, there is also a very thin line between the broad delegation of powers and non-management of the companies. So actually there is no clear ex ante solution that might be a good one in order to solve the problem we are discussing. Another drawback is that all of those solutions would be one-size-fits-all measures. That's the same problem we had, for example, with the minimum capital requirement, that it was a one-size-fits-all measure applied to all the companies, and that was always one of the main points of critique directed towards it. So, in my opinion, the only solution that could and that should be applied would be the ex post measures, the liability of the de facto directors. Of course, there is also the drawback consisting in the fact that it's usually quite hard to prove the de facto management and to prove who actually was the de facto manager. But that problem could be solved by shifting burden of proof. Here we can see some similarities to the rules applied in many legal orders with respect, for example, to Actio Pauliana. So to sum up, on the basis of our Polish experience, I do not feel that the lack of rules on shadow directors is a good solution. In my opinion, liability of shadow directors should be provided by law, should be explicitly regulated by law. The ex post measures seem to be a much better solution. And thirdly, I do feel that the issue of shadow directors needs to be regulated on the EU level, not only on the national level, as all of those rules, when they're applied only on the national level, might be quite easily circumvented simply by using a company incorporated in another jurisdiction. Okay, that's all of my remarks. Thank you very much for your attentions, and I will be glad to answer any questions if they arise in the later discussion. Thank you.
Thank you very much, Marcin, for your presentation. I also want to use that time to again remind everyone to make use of the chat function to post potential questions now, but there will also be time to ask them directly after we finish our session of presentations. Our next presenter will be Sergio Enriquez, who is assistant professor at the Universidade Lusófona Law School in Lisbon. And he will actually pick up a little bit on what Marcin also talked about. So he will present us with some comparative insight into the pre-insolvency duties of directors. Do we have our speaker here?
I'm not sure if Mr. Sergio is here. I tried to find him, but I couldn't in a participants list. So if he is here, please turn on your microphone and your camera. Maybe it's under other username, but I'm not so sure.
Yeah, I'm also looking through the participants list and I don't see him. So maybe instead of maybe he'll join us later and maybe we can switch maybe we can switch and now Professor Boeva could present, as we are also a little bit late in our time. I hope Professor Boeva is here with us.
Yes, she's here.
Okay, so Professor Boeva was originally supposed to present in the first session, so you can find the title of her presentation in the conference program within the first session. She's a professor at the University of National and World Economy in Sofia, Bulgaria, and she will present us some insights from her research regarding global value chains. Professor,
okay, do you see my PowerPoint presentation?
Yes, it's visible.
You see how many minutes I have? 7?
15 minutes.
I beg your pardon? 10 minutes?
15.
15, okay. You see, I would like, first of all, as previous speaker said, thank you very much for the invitation. Second, I would like to be excused that with my first, with my first thoughts I would like to share with you, I'm breaking the rules of this conference. Why? Because Professor Horak told everybody not to refer to old previous studies. But also, previous speaker, Marcin, provoked me with this football game start. So I would like to say that I'm working on the global value chains from the perspective of corporate governance. And in my maybe more than 5 years, but in my previous study, I published a paper on global value chains and human rights perspective. And here on my screen, you see information about the adverse human rights impacts during the construction of different facilities for this World Cup in Qatar. And meanwhile, it was FIFA, the organizer of the current competition in Qatar. They decided to mitigate the expectations of the public to do something with this human rights abuse. And it was FIFA that started to comply with United Nations guiding principles on business and human rights. And especially the advisor was Professor Rugi. Unfortunately, he passed away a year ago. So that's why I would like to put together this event, which is on the agenda of many people, but also it is not far from the issues we are discussing today, and also I'm discussing today. I would like to just say that it is a paper. Of course, I'm sure that I have to work a little bit more because there are certain questions which I'm not finding the proper response. And as you see, I would like to see how does the current legal regulations in European Union is tackling the issues with global supply chain and especially adverse environmental impacts and also adverse human rights impacts on various stages of global supply chains. The thesis of the paper is that we have at present due diligence directive. Of course, it is a draft. Also, we have corporate sustainability reporting directive, and it is supposed that directive will be published officially by the end of this month. It is on the one side, we have this regulation. On the other side, we have a lot of companies that refer to their global supply or global value chains. And in this paper, I'm looking for the arguments. It is written here, the consistency of these directives, and also the capacity of the companies to comply with this document after their transpositions. Or stating a different way, on one hand, I would like to see how the business issues, economic issues, corporate governance issues are mitigated by or tackled by these quite new documents on the level of European Union. How this paper is structured, as usually, because my background is economy, but also I had a degree in law, but I'm not practicing law. So I'm trying to just reflect a bit on the economic nature of global supply chains and the problems within business relations. Later on, I'm trying to see these efforts of the European regulators on national and on EU level to tackle with these issues. Later on, I'm trying to see the expected results. And my final thoughts I would like to share with you about the future of sustainable corporate governance as well. Concerning the research, methods, I focus on, as you usually say, on a literature survey. Especially I use Scopus and ProQuest. Also, I use gray literature survey. For me, it's a little bit new, this term, gray literature, but gradually I'm finding that many scholars, especially in the area of corporate governance, international business as well, they refer to Great Literature Survey, information from the websites of NGOs, media publications as well. Of course, I try to go very carefully to 3 documents of European Commission and European Parliament, and I'll refer to these documents. And also, I try to do, as we say, field research. I interview CEO and also CEOs of some Bulgarian companies who are supplying some components for the big transnational companies. What are the results of this paper? I try to put here on this slide, of course, I know that it is not so easy to read, to put the results of my different approaches toward the studies of global value chain. On one hand, I try to look for studies by economists. I also try to find answer to the question in the publications of the scholars from international business theory, as well from corporate governance. In my paper, I stick to a definition about the global value chains that encompasses different types of relations, commercial, contractual, manufacturing, as well logistic, transport, marketing, information between companies. Here I would like, it is my how to say, understanding at this as a system. What did I find in the literature, not only literature, but official publications? At present, I'm talking about year 2022, we have the usage of global supply chains and global value chains. Certain institutions are promoting the interchangeability of the terms. In the OECD documents, the focus is on supply chain. As we see, as we know, it is only part of the value chain. And here I'm coming with my comments and questions, and I'll later continue on. At present, in the draft Corporate Sustainability Due Diligence Directive, the focus is on the value chain. And on the other hand, in the Corporate Sustainability Reporting Directive, there the usage of supply chain and value chain is a fact. You know, I'm part of certain groups that discuss these issues. I'm talking about ECODA and other groups. And still there is no one unified view what is better, value chain or supply chain. And it is not a problem only for discussion today. It is not a problem of the theory, but it is a problem of the practice. And as you see here on final part of on this slide, that it is better to use supply chain. The focus is on the supply side of the value chain. It means design, it means extraction, investments, design, production. The demand side, marketing and trade, is also sensitive to the problems in terms of violations of human rights, violations of environment. I'll stop here. But you see, it is very difficult to go on this demand side. Of course, the It is well known that certain consumers, practically, they are engaged on the marketing and the trade side. I'm talking about the millennials and Generation Z. They are also trying to elevate the problems with the CO2 emissions. They're also elevating the issues of human rights abuse. But the most problems which are related to adverse environmental impact or adverse human rights impacts are taking place on the supply chain. So that's why I'll go later on with my comments on the directive. It is necessary the lawmakers to find the one view, because the people in the practice, the business, will have to comply all these things. And now I prefer to put this thought video on what did I find and what did I study at present in terms of EU legislation. I'm sure that the term sustainable legislation is, how to say, also is not correct. But here I'm focusing on these documents, directives, regulations that tackle the above mentioned issues, the problems of human rights abuse, environmental abuse on the various stages of global supply chains. I tried to go very deeply, very thoroughly, excuse me, through 3 documents. The first one, I'm sure it is not in the focus of many of people here today, is the regulation, and this regulation is about the due diligence obligations of companies in Europe, which import certain ores that are originating from conflict-affected and high-risk area. It is not something unique, because maybe some of the scholars here are familiar that Dodd-Frank law in United States put the same requirements many years ago. Also, my next interests were directed to the corporate sustainability reporting directive, and also to the proposed standards of EFRAG, European task force that is responsible for the preparation of standards for sustainable reporting. And finally, I tried to see how the problem with all this environmental abuse, human rights abuse, are met in the corporate sustainability due diligence directive. Of course, I'm working with the draft version as well, the latest proposed amendments by the jury committee of European Parliament. That's why I wrote here November 22. Also, we have to mention here that certain countries from certain EU member countries like France, Germany, excuse me, it's Netherlands, and the Netherlands have passed their laws. I'm talking only about the EU member countries. And also, we know that still in force branch agreements between the companies, for instance, which are engaged in apparel industry from Europe with their partners in developing economy on the other side of the supply chain. What did I find? I'll try to be very brief. Of course, as I said, lack of consistency with regard to terms and definitions about value chain and supply chain. Regulation, which is on the ores from conflict zones, it's only on supply chain, although that they practically talk about the whole value chain. As I said in my previous slide, directive about sustainability reporting use without explanations why value chain and supply chain. And as I said, corporate sustainability due diligence, the newest one, focus on the value chain. As I said, different definitions. And you see, the problem is that we have to put together the economic nature, the business nature of this phenomenon with the norms that the lawmakers are using. That's for me, it's very important. And not for me as a Professor Boeva, but again, I'm trying to be in the shoes of the companies that will have to comply with this directive. Also, one problem, and later on and here I'm offering you an argument. Although that there's some decisions, or let's put it this way, programs, how to tackle all the various subcontractors on the supply chain. At present, EU legislation, I am focusing on the due diligence directive. They try to put norms for the companies for due diligence process only for their first supplier. In the new version, they use the term cascade approach, or put it a different way. It means that provided a Croatian company is working with company from, let's say, Senegal, or okay, it's a torn issue now with regard to the football players. And Croatian company has to do diligence only for the first tier supplier from the company from Senegal, and it will be left to the discretion of this Senegal company, the company from Senegal, to do diligence on the next stage. But of course, in this document, Corporate Sustainability Due Diligence Directive, it is clearly stated that European Commission will propose new type of contract with strict norms about this cascade approach, but we are not sure. And for me, I'm referring to my previous studies, the thorny issues are these remote suppliers. I know, and it was discussed during different meetings on what and why the directives on the remote supplier, that for the companies, it is very difficult to look at the far end. But you know that in certain cases, it will mean that we'll comply with the directive, we'll reveal who is our first supplier, but maybe we'll have problems with the remote supplier. And in my study, I found a very interesting project and study prepared by Leiden University. And in more than 300 pages, referring to a lot of figures, statistics on the trade between China, one of the China's region, and North Korea, they found out that a contract, traditional contract in apparel industry between the CNA, the company with a lot of international retailers, say CNA, and Chinese company, this practically contract is outsourced to a factory in North Korea. And this study is referring to the fact that the conditions in the North Korean factory was awful, and they use the well-known word modern slavery, modern day slavery. I would like to go a little bit, maybe a little bit outside, but also because we have people from Poland, this study also proves that certain problems took place in factories, in construction in Poland, where people from North Korea are working on the construction sites in the Poland. But here, okay, excuse me for this deviation. My argument is that when it is possible, the regulators, the lawmakers, has to think more about this remote supply. In the paper, I'll stop here. I try to develop a hypothetical case with two alternative supply or value chains. One is when a company is importing minerals from conflict zones, and the company is doing due diligence accordingly. The other alternative case is about a company is importing, let's say, processed metal from, let's say, an African country X, and they are doing due diligence about this supplier, but they do not go further, and it happened that this African country has as a first or remote supplier companies from these conflict mineral zones. So maybe I'm wrong. I'm trying to see how the issues about the human rights abuse, environmental abuse are tackled with, by this new document. And the next problem I'm trying to the study in this paper is about the disclosure. I know that I went very carefully through the program of this conference, and I saw many people who are working on the latest development on sustainable reporting within EU. And what did I found? That both directives, and it is not something which surprised anybody here in this conference. Corporate Sustainability Due Diligence Directive envisages the disclosure and of information and publication of due diligence report. And it was clearly said that the statement has to be aligned with these well-known accounting directives, with especially Article 20 and 19 management report and corporate governance statement. I'm sure everybody knows what is going about. There is no reference, or maybe in the final version there will be, but the current version don't refer to corporate sustainability reporting directive. And I would like to point out that this directive envisages the disclosure of topics that are related to human rights, of course, and human rights abuses, to the climate, to the CO2 emissions. And here I mentioned the articles 1998B and that are envisage the disclosure of this information in the annual dam management report. Or putting another way, I'm still questioning how the company, which has to comply with these transposed directives in their home country, how they have to prepare a report. Or maybe it will be just rubber stamping. I do not know. I'm not asking for this question now. And here, again, at that point, a question for me arises about the harmonization of disclosure in these two directives. Of course, we know that there will be EFRAG standards, but again, there is no harmonizations in terms of directives. And as I said, for me, the problem is the company. I'm not sure that all regulators have been in the shoes of the companies, but you have to have capacity, and especially the latest changes in this directive envisages that due diligence directive has, and the transposition has to be the companies with about 250 employees have to comply. In previous version, the scope were the companies with 500 employees. So, and we know what is in our countries. To make the story short, I try in this paper to put certain questions, to find certain answers about how the problems with the global supply chain. I see the global supply chain as a part of the corporate governance. Second, I try to see how certain documents, regulations, directives are tackling the issues with three main domains. What is it? How they define the objective of these regulations, directives. Second, the harmonization. And third, the problems with remote supplier. And fourth, the problems for the company. And of course, I would like to also to underline the positive. I'm very glad to all this take place in Europe. And we have to say that these new directives and old regulations are enabling new developments in what we do in corporate governance, especially with focus on the purpose, enlarges the scope of sustainable reporting, and of course, contributes to the avoidance of problems. And finally, support that EU Green Deal. I see Anna-Marie, and I think I'm coping. I didn't touch the link between my presentation and the current understanding about the purpose of the company. I stopped here. And I would like to say thank you very much for this opportunity to participate in your conference. And I'll be glad to answer certain questions, not today. You have my university email, that's for sure. And provided you'd like to contribute to my study, I'll be delighted. Thank you very much.
Thank you very much for this interesting insight into your knowledge about and your studies about global value chains. Our missing presenter will probably not join us now. I think he's still not amongst us. So we have finished the first part of the session where we finished the presentations, and we can now turn to any potential questions that may arise. We had in the meantime a short discussion and several questions within the chat, which were directly answered also by our two presenters who also had to unfortunately leave us a little early because of other commitments. So if you agree, I'll just I just point to the discussion in the chat, which you can now reread as it covers the answers to these questions. But I would like to encourage all the participants to now either formulate their questions in the chat or raise their hand and ask their questions directly. Maybe for the time it takes to get the first questions from our audience, I will give myself the pleasure to ask our first presenter, Ariel Mucha, a question. So Ariel, when you discussed or critiqued the various points that are connected to the topic of applicable law for directors' duties and directors' liability, we kind of stopped, of course, also because of time reasons, but we stopped at the point where you said that there maybe is some space for some legislative intervention. Maybe you could elaborate a little bit more. What do you think? What would be the, the proper or the best legislative solution that would accommodate these various problems that you raised?
I mean, the best solution would be to harmonize the director's duty on the EU level, and there will be no problem which law we need to apply, since it will be universal approach to the director's duty. But this is very wishful thinking, and we are very far in Europe from this kind of solution. Second thing, we can harmonize the law applicable to companies, so to resolve the different problem that arises when we are dealing with issue that can be characterized as company law or other fields of the law. But I got this temptation that what we should do in such situation, I really would like to see that the Court of Justice will use such measure like public policy clause or overriding mandatory provision. Two institutions very well known for people dealing with international private law. So like in this case, I mentioned about this imaginable Swedish furniture company. I would really stick in this kind of situation to the corporate law. If we got a duty imposed on directors, we should apply corporate law. So far that they are acting in the interest of the company and act in a reasonable manner in this interest. Yeah, so in this case, we would apply Swedish law. Obviously, it may raise some problem with forum shopping. So immediately this company can move to some jurisdictions which just impose less stricter standards, but then we should refer to the public policy clause. So you can't live in the safe haven if you are doing business in Europe. Yeah? There are many instruments. Yeah, and in case of like torture, human rights abuses, yeah, I think the Europe should impose European standards. And I mean, this is what I see as the best solution currently, and also in case of sustainability goals and regulation that are enacted to achieve these aims, that should be also standard that is introduced, or it's embedded in the public policy clause. What I don't understand, because I'm giving a lecture on international and private law, and when I'm discussing the public policy clause in Poland, the only cases I discuss is the problem of same-sex marriage, which according to the Polish Supreme Court is not allowed because it is against Polish public policy clause. It's crazy, it's insane, but that's what the case law is now. And I really have a problem, why not use this public policy clause in more sensible cases, like, for example, forced labor problems, and I don't know, these all problems connected with human rights abuses. So yeah, it is, and answering, maybe concluding to your question, yeah, there is a plenty of instruments in international private law. Just let's use them in practice. That's my main solution.
Okay, thank you very much for your answer. Speaking about possible harmonization and the issue of wishful thinking that you raised, I would like to ask Marcin Mazgaj, because he also discussed the various ex ante or ex post mechanisms that could address the problem you explained and raised during your presentation. Do you think that this issue of identity theft, also bearing in mind the increasing mobility of companies within Europe, do you think that this could also potentially be an issue for a harmonized legal framework, or would you rather say that this has to be addressed by the member states themselves?
No, I'm sure that this is an issue that should be harmonized on the EU level. Look at the example that I described in my presentation. It was not a coincidence that the person who was entered as a management board of that company was a Swedish citizen, not a Polish citizen. Because in case of Polish citizens, it would be easier from the point of view of the state of registry courts, police, etc., to well, find that person and to simply check whether actually such appointment to the management board took place or not. In case of a Swedish citizen, it was a little bit more difficult. So, well, definitely it should be harmonized on the EU level, because otherwise, even if we regulate it at the national level, thanks to the judgments such as Centros Übersehring, etc., it would be very easy to circumvent such national rules.
Okay, thank you. Thank you so much. For anyone from the audience who would like to ask a question, please use either the chat function or raise your hand through the dedicated button. And since I do not see any questions, okay, Professor Horak.
Okay, thank you, Anna-Marie. Just one opinion from Marcin regarding the theft identity. So, as we heard, and it is obvious that the directive on digital tools regarding this issue will be implemented in a different way. So, do you think that member states will go beyond and above the directive, or they will leave it?
I think there is no one simple answer to that question, because already some member states go beyond that. In Poland, we can create companies digitally for, well, more than 10 years. And I have to say that the identity of the shareholders is quite well checked during that procedure, but not necessarily the identity of managers of the company. Well, I cannot provide one general answer, because I think that not all the member states will go beyond the level of protection required by the directive.
But for example, from the Polish view and from the Polish perspective, what in practice also, what do you think? Because if we are referring to the cases from the freedom of establishment, we can see that there are a number of problems still existing. So, and that national courts, of course, are protecting on the national level. Then the Court of Justice of the European Union is of course, ruling in favor of the four freedoms, etc. And of course, for sure, the Court of Justice of the European Union will rule in favor of digitalization and implementation of the digital tools directive in the practice. So I see also, again, a lot of misunderstanding. And when we speak about the identity theft, it is quite, I must say, serious issues. So tax evasion, etc., with all this criminal also background. So That's
Well,
my
also-
concern, how it will happen. I'm usually always quite curious regarding the effectiveness of directives when we speak about the implementation and harmonization in national laws. So,
well, in Poland, we had also one interesting experience as regards the digital formation of those companies, because at the very beginning, when the rules on digital formation were introduced, you could establish a company without having any special digital signature. You simply needed to create an account in a special digital system created by the Ministry of Justice, but it worked like creating an account in any shop in the internet when you're doing the shopping. Yeah, so of course there were some problems related to that, and then the rules were of course changed, and nowadays you either need to have the digital certified signature, or you can use the also digital but sort of official signature that each citizen of Poland has. So there is a certain level of protection against the identity theft, but it is partly due to some earlier experience.
thank you very much, Martin. Thank you, Anne-Marie.
Okay, thank you. Are there any other questions from the audience? Okay, so I have a last question I would like to ask Professor Bueva. I think this question also rounds up our discussions within the first and the second session that we're evolving around strongly around the topics of ESG and also directors' duties. I would like to ask you, you have so much experience with the regulation of global value chains. What do you think the component that was foreseen in the Corporate Sustainability Due Diligence Directive, that is Article 25, that established a, let's say, harmonized director's duty? Now, I know I wasn't able to find this information online, but the information is circulating that this provision has been dropped out of the directive proposal already. But do you think that the harmonization of directors' duties, do you think it is an important component of the regulation of global value chains at all? Or do you think the European Commission just tried to add something on top of the value chain regulation, and that it is not needed in the whole structure of regulating value chains?
As a university professor, I try to go around and around. You see, first of all, be advised that prior this directive and corporate sustainability reporting directive, there was a very interesting study done and proposal done by E&Y. And one of the conclusions, maybe you're familiar, it was maybe 2 years ago. And one of the topics was about the duty of the duties of the corporate directors, as well certain proposal. And one of the concerns among the business community, I'm talking about colleagues, not university professor, what about that it is an extra burden because you have to know extra knowledge, or you have to have an extra person at your board of directors, a supervisory board, who has to have a special expertise in the area of sustainability issues. So again, it goes about the fact that you see, it is, for me, it is an extra burden. It's an extra burden. Of course, you can harmonize, but at the end, at the level of the company, an XY country in the European Union, they will comply, but formally. And also here, I'd like to say, give more space to the directors to run their companies accordingly. Again, you see, my concern is, I'm going back, we have to be in the shoes of these people. And also, I'm not quite sure, do you have chance to follow the contributors to different discussions, even the contributors to the latest discussion on corporate sustainability due diligence directive? And more of these contributors are either NGOs, excuse me, or certain branch associations. So again, the opinion of the business community on this issue in Europe differs. I think that I try to answer in a way, trying to give you the certain pieces about the story.
Okay, thank you. Thank you so much for your answer. We have reached the end of our session. I wanted to thank all of the speakers for their interesting presentations. I also want to thank the audience for being here in such a great number. Thanks for the organizers for letting me chair this session. It was a great pleasure, and I wish everyone a fruitful discussion again today in the afternoon and also tomorrow during the second day of the conference. Thank you so much.
Thank you, Anne-Marie. Thank you all for today's attendance. And I would like to invite you to the European Law Institute Special Interest Group Business and Financial Law session, which will start at 15:30, 3:30. So in 15 minutes, it is open to all those who have interest in the topic, and I think it will be worth to hear. We will present our project, which has been approved within the European Law Institute, guidance on company capital and financial accounting for corporate sustainability. So it fits completely within these topics that we heard today and within the conference. So you are all very welcome to attend the next session. Thank you very much.